Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Appeals Court. Our apologies for the delayed start. We had a Zoom argument and some difficulties getting that going, but that's concluded. I'm Justice Peter Sachs. To my right is Justice Robert Brennan. To my left is Justice Andrew D'Angelo. Will be your panel for the remaining 4 arguments on today's list. We will be taking a short break after this argument to rearrange the courtroom to accommodate a fully in-person argument. But this argument is on partly by Zoom. If you've been to the Appeals Court before, you will know that we have 15 minutes per side for argument. There's no rebuttal. We have read your briefs. We are familiar with the facts and with the procedural posture of the case, so we would suggest that you get right to the heart of your argument. In the courtroom, you'll see some lights in front of you. The green light means go. The yellow light means you've got 90 seconds. The red light means your time is up at the end of 15 minutes. Mr. Hickson, you will not see those lights on the Zoom screen, but I will let you know when you've got 90 seconds to go, and then again when your 15 minutes is up. So you'll get notice of that. All right, so with that, I'll call the case, number 22, P1042, BREANA Williams versus John Hickson. And it's Mr. Stewart.
Yes, good morning, Your Honors. May it please the Court, my name is Attorney Robert Stewart. I represent the appellant, BREANA Williams. Ms. Williams is here in the court with us, with an interest in the case, obviously. And we're here, Your Honors. The issue of the case is who owns the dog Sadie. And we believe and we submit that the trial court erred as a matter of law in finding facts sufficient to determine and order that BREANA Williams gave Sadie to John Hickson as a gift. We believe that is not the state of the evidence, even accepting as true what the trial court found in the factual record, that the elements of gift, the legal elements of gift, were not met.
What role, if any, does the adoption contract of the animal play into the plaintiff's ability to gift the dog to someone else?
We believe, Your Honor, there are 2 important considerations regarding the adoption contract. One is the fact that the adoption contract in paragraph 6 prohibited a further conveyance of title, prohibited BREANA Williams, the adopter, from conveying out to anybody else, anyone not named in that contract, her title to the dog. And if that was her intention, Your Honor, her only legal option under the contract was to return the dog to No Greater Love Rescue.
So what standing does she have to enforce that contract, really? Like, if she in fact wanted to, and if she did everything she needed to do to actually gift the dog, and then 5 years later decided, no, kind of reconsidering, do you think she could then go in and say, well, look, this contract says I couldn't give you the dog, so let me have her back?
Your Honor, it goes to her capacity, but it really further goes to the state of her intent at the time of the adoption, Your Honor. And if I may, because the trial court's order is written referring to parties by their first names, I intend to use first names if that's okay, with no disrespect intended. So BREANA adopted Sadie. BREANA did not, based on the evidence in the adoption contract, intend to convey her interest to Sadie to anybody, particularly John Hickson, because the contract itself would have reflected that, Your Honor. And I think it's important to look at the case law, especially, Your Honor, if directing your attention to the Edinburgh case.
Let me just hold you off on that one, though.
Sure.
Because anybody who's adopted an animal, and I can say we probably in my family over the course of the last couple decades, yeah, we're in double digits, for sure. Those contracts, no one really expects that. I mean, sometimes you go in and I don't have a fenced yard, so yep, okay, I'll say put my name on here because I have the fenced yard and you don't, and then I'll take the dog. Or the cat, they say the cat can't get declawed, but I live in an apartment and I wouldn't personally do it, but I want the cat declawed, so I'm going to say something else. So you're saying because the adoption contract says you can't declaw your cat, you have to have a fenced yard, that somehow is something that that is indicative of the party's intent once they get the animal toward other folks and how they gift them?
Yes, Your Honor, we submit that it does. We submit that the way that the contract is drafted, you'll see that this was not a casual, this was not a casual process. Each paragraph is individually numbered. It wasn't as if there was any question in BREANA's mind as to the existence of that clause. She testified to that as well at the trial, that she knew of that clause. It's again, it's the intent to give the gift once the title to the property is acquired that is what the court needs to look to, we submit, and what the trial court overlooked. Otherwise, any statement of intent is simply a statement of some future intention, which we know from the Jerry case, from the Cardoza case, a statement of future intention to do something without following through and doing it is not a gift. We submit that the law of gift, while it isn't overly complicated, Your Honors, it's very specific. And the facts need to be applied with some rigor as to whether title to property transfers by gift or not.
How do we know where there's no written title, as there is to an automobile or a piece of real property? How do we know who has title?
Yes, Your Honor.
Because that's not something that lay people necessarily talk about when they co-own something, or when one or the other of them purchases it for the use of both of them, or enjoyment of both of them.
Correct, Your Honor. I would agree with you. I would submit, however, that under the law, we can go back to the McGee versus Scott case. And this is, again, something that the trial court never did. The trial court said there's a paucity of evidence about what constitutes ownership. Well, doing legal research on what constitutes ownership, you come to a line of cases that starts with McGee. I cited it as McGee, and I apologize, it's McGee. McGee v. Scott, it says this, Your Honors. It says the ordinary mode of proving property is proving that it was purchased and paid for, both in this case by BREANA Williams, purchased and paid for, will be deemed in law to be the purchasers until something is shown to change it. So any evidence that predates her purchase and paying for it, which I believe was March 9th of 2020, anything that predates the adoption contract and the tender of the purchase price, purchased and paid for, those are only statements of future intent, Your Honors.
But those are something that the trial judge or the hearing judge can consider. Can't limit it, but it can consider it in deciding ownership. If I say, I am going to buy this car and I am going to gift it to my son, I go and buy the car, I get title, that intent of mine, that future intent, could later be used by a judge in figuring out what I want to do. It's not the sole thing, but it's something a judge can consider, correct?
Yes, Your Honor.
So in this case, the judge considered at least what Mr. Hickson said about when she got Sadie, what her future intent was in considering whether this was a proper gift. Didn't the judge?
Yes, Your Honor, the judge did that.
What's wrong with that?
I wouldn't say there's anything wrong with finding the fact to be true, and we have to accept that. I wouldn't submit that there's anything wrong with the judge making some inference from that. The problem we have, Your Honors, is that the judge's order, the judge's rulings, never once mention what the law of gift is, what the elements of gift are. They're rather simple, but again, they're specific. There has to be a settled
If we accept her findings, then can we affirm if we conclude that those findings support her ultimate conclusion, and those findings support the application of each element to determine that the ownership of Sadie was given to Mr. Hickson?
We would say no, Your Honor, because accepting the findings of the judges to the 3 facts, she cites to 4 facts, the 4th being that John spent time with Sadie at his home. But on page 6 of her decision, she cites to 3 other facts that, while she doesn't say anything about why she's citing them, presumably they go to intent. One is that John as a child wanted a certain type of dog. That obviously predates the acquisition of title by Breanna Williams, and there's no evidence that Breanna knew of that. That just said that that's what John wanted. 2, that the judge found that Breanna Williams stated intent. And remember, please, Your Honors, that Breanna Williams denied at every turn and on all questioning that she ever had the donative intent. But second, she said, I wanted to get this dog as a companion to my other dogs. And the judge said, well, I'm not so sure about that. Still, that's what she wanted to do at some point in the future. Third,
Can the judge decide not to credit her testimony about that?
well, sure, yes, Your Honor, but if the judge credits the testimony that that was part of the motivation and showed donative intent, it is still under the case law. Those are, if you look to the Cardoza case, Your Honor, words without delivery are insufficient. The intent was never carried out. It's after the time that Breanna Williams obtains title. That is the only point at which the statements of donative intent have any relevance to the law of gift.
Why can't these statements be made in advance of the acquisition if what the conduct of the parties after the acquisition tends to confirm them?
Your Honor, we would submit.
Why can't we presume, I mean, once a state of affairs is established to exist, in this case, her intent, why couldn't the judge presume that that intent continues unless it's shown otherwise?
Because that intent of a future action is not enough under the law. Jerry v. Howe, Your Honor, says that, the Jerry v. Howe case says, Your Honor, that an intent to give a gift is not a gift. The right of property, the court goes on to say in that case, could only be found by perfected gift. The law uses the word perfected gift.
How would that hypothetically have occurred in this situation, then? If it was not perfected, give me an example, or give us an example, if you would, as to what would have happened or could have happened to actually perfect the gift.
There's 2 scenarios, Your Honor. There could have been testimony offered that after Breanna Williams acquired title to Sadie, she said something, anything, to John Hickson, here's Sadie, your dog that I got for you. Or, Your Honors, you could follow the line in the Edinburgh case, where the Edinburgh case said, okay, we've got a problem with delivery in Edinburgh, there's artwork. You know, these people can't take it and put it in their garage. But the court in Edinburgh said, this donor made lists, this donor tagged property with people's names on it. So the other scenario in this case that the court could follow, and we believe the trial court was obligated to follow if they were going to find gift, was to say, okay, well, the adoption agreement, that could have included John Hickson's name. The microchipping of the dog, which took place after acquisition. If Breanna Williams had meant the dog to be John Hickson's dog, why would the microchip not be in John Hickson's name? The veterinary records, Your Honor. The veterinary records, if John Hickson was going to own this dog, John Hickson needed to be on the veterinary records. And Your Honors, the evidence of that is after John Hickson took possession of Sadie involuntarily. The parties were at the police station. There was this handoff to John Hickson's father, and by Breanna Williams' sister. John Hickson then tried to get veterinary care for the dog and could not because he was not an authorized care. He was not authorized on the veterinary records below. That is evidence of the dominion and control over the dog.
At the veterinarian in Connecticut.
So the veterinarian in Connecticut, which was the veterinarian that cared for the dog while the parties were together, there was no record that John Hickson had any ownership. That would have been a scenario, Your Honor, where you would have looked at the records and say, oh, well, of course John Hickson's a part owner. John Hickson's on the veterinary record.
Why isn't these two findings of fact enough that we could conclude that the gift was perfected, so to speak. One is the testimony that that from John, which the judge seemed to have credited, that BREANA told John she was giving him the dog because she thought it would help their relationship, which I know is a future intent, but that fact, and then the fact that during the time Sadie lived at the house, John would take her to his parents' house in Springfield on a daily basis. So there's been a giving of the dog to John on a daily basis. Why isn't those two things enough that it's a gift?
We would say, Your Honor, two things. Giving of possession, absent an intent to transfer title, absent an intent to give gift, is simply possession without delivery.
So we need the
gift.
words from BREANA, this is your dog, as opposed to, I am getting you a dog for you to keep. That's the linchpin of your argument, that it has to be after she gets the dog to say, this is your dog, as opposed to, I am getting you a dog. That's it.
Your Honor, it needs to be we would suggest two things, Your Honor. For the trial court to say that the evidence proves gift, but for the trial court to fail to go through the analysis of what is a gift and what the difference is between a statement of a future intent and a settled donative intent coupled with delivery. Again, it's our position, Your Honor, that this law, it is not complicated, but it's very specific, and the facts need to be applied with rigor.
I just want to make sure I understand your argument. Does your argument depend on us finding any of the findings of fact to be clearly erroneous? Because without the whole transcript, I don't see how we can do that.
No, Your Honor, you do not. You need to find that the three statements that the judge accepted as proving intent were mere statements of future intention, and that after acquisition of title, it was purchased, it was paid for, it was owned by BREANA Williams, and there is no evidence that there was any future transfer of title beyond that. So you do not have to overturn any of those court's findings. With that, Your Honors, we would ask that you find that the trial court erred as a matter of law, that this was not a legal gift from BREANA Williams to John Hickson, that she has legal title, and that she owns the dog Sadie. Thank you.
Thank you, and we will now hear from Mr. Hickson. And if we appear to be looking to the side, it's because the screen that shows you is over to the side of the bench. So we're looking right at you, even if it looks to you like we're looking away from you. So why don't you go ahead? You have 15 minutes, and I'll let you know when you have 90 seconds left.
Thank you, Judge. Thank you. And welcome to the panel. Yeah, obviously, I'm not a lawyer. This has been a very long and drawn out case that's taken a lot of personal, mental, physical, emotional toll on me. You know, she's my dog. She doesn't have, you know, like a long, excuse my emotion, but she doesn't have a long life expectancy. She was already taken away from me for 1 year during this process the first time. We went to court. I gave the dog back because that's what they said I had to do. We went to court, and through the due process of a week almost of this, Judge Goodwin ruled in my favor that Sadie was my dog.
Mr. Hickson, did you know anything about the adoption contract that Ms. Williams had signed that said that she couldn't give the dog away?
No, Judge, I did not.
So can I ask you, you say in your brief that when you got the dog back, the dog Sadie appeared to be malnourished and underweight, but there's nothing in the record that would support that. You didn't. Go ahead.
Sorry. I'm not exactly sure what you mean by the record. I do remember stating after we got after I received Sadie back, she lost a lot of weight, and when I brought her to the vet over here in Massachusetts, they said that she needed to gain weight. She wasn't. She didn't have all her shots up to date, and she didn't see a vet the entire time she was in care of Breonna Williams.
So I guess what I'm saying to you, sir, is that's not part of what we have. We don't have those records, the vet
Okay.
records. We only have your statement in your argument, as part of your argument. That's what I'm,
Okay.
Okay.
Yep.
sorry to interrupt you. Go ahead, sir.
You can continue with your argument.
That was pretty much all I had for that.
The judge in her findings said that you trained Sadie and that you spent more time with Sadie than Breanna did due to her work schedule. What was the schedule like when Sadie was living with both of you?
She was always with me. Yeah, every day. If she wasn't with me in Connecticut, I brought her back to Massachusetts, to my parents' house, where it was basically like a little daycare. You know, she loved being with my parents, and you know, this was like her home too. So, yeah. So Brianna's work schedule was, she worked a lot. She had 2 other dogs as well, that, you know, never really went outside, they went to the bathroom inside and stuff. So, you know, and I didn't really like the environment for Sadie to be in and to like grow up around. So, I would kind of I was trying to get her out of the house as much as possible. Yeah, so I trained her how to do everything. How to go to the bathroom, how to go for a walk, you know, how to eat, pretty much everything.
Okay. Further questions?
No, I don't.
All right, Mr. Hickson, the panel has no further questions for you. Unless there's anything else you want to add, you do have some time left, but you don't need to use it all. So if there's something else you want to say, why don't you say it now, and then we'll end this argument.
Thank you. Yeah, you know, the last thing I would like to say is, you know, kind of just finishing up on what I touched on earlier. You know, she's my daughter. Like, I look at her like she is my daughter. She has been my daughter since day one. You know, this is, again, we've been in this process for a long time. You know, without a lawyer, and you know, it's been ruled in my favor a number of times. You know, I would like this to be over with. Like, I just want this to be done. I just want this to go away. I just want to be able to enjoy the last, you know, precious years of her life, you know, with, you know, the family and children that I have, you know.
All right, thank you for your argument. Thank you to both parties, and we'll be in a brief recess and then resume with our other 3 cases.